This is a podcast from Duncan Cartlidge Online, the online resource for all construction professionals that's available 24/7. Now please don't forget to subscribe at the place you usually get your podcasts so as not to miss a thing in the second series, as well as visiting our YouTube channel. Hello again and welcome to another podcast from Duncan Cartlidge Online. As usual, Barney, my red Labrador, is here to offer advice and to keep an eye on the proceedings. In this podcast, we'll have a look at collateral warranties, what is practical completion, and finally, the continued fallout from the collapse of ISG. So let's kick off this fourth podcast in the second series with a look at collateral warranties. Collateral warranties create a contractual link where none previously existed and give interested third parties a right to bring a contractual claim against parties that say designed or built a project. Collateral warranties are contracts like any other, and in common with all contracts, they require an offer, an acceptance, consideration, and an intention to create a legal relationship. The word collateral refers to the fact that they are related to and dependent upon another contract. The word warranty represents an undertaking from the performing party to the other that the performing party has fulfilled its obligations under the principal contract. Therefore, we can say that collateral warranties are a side agreement between project parties who do not have a direct contractual link. They are typically used by project funders to enable them to have recourse in the case of design defects and in management contracts where the employer has no direct contractual relationship with the work package contractors. Some collateral warranties with funders can offer step-in rights in the event of employer defaults, and this can bring significant benefits to the contractor, such as the right to payment for unpaid sums. There is usually no need for a collateral warranty to be provided in favour of other parties to the principal contract, as any required terms can usually be incorporated into the principal contract. As you would expect, there are standard forms of collateral warranty, such as the suite of forms published by JCT and the CIC. These forms impose several limits on the liability of the person providing the warranty, and for that reason they may not be acceptable to the third party. In practice, most employers will usually use their own bespoke forms of collateral warranty. Collateral warranties are typically executed as a deed to provide a 12-year liability period for claims for breach of the terms. An important question which has recently been resolved is, do collateral warranties qualify as a contract? This is important because if they do, they become subject to the Housing, Grants, Construction and Regeneration Act of 1996. The Act, also known as the Construction Act, is intended to ensure that payments are made promptly throughout the supply chain and that disputes are resolved swiftly. This was a direct result of the 1994 Latham Report. There have been two important cases on whether collateral warranties constitute a contract. The first case is Parkwood Leisure Limited versus Lang O'Rourke Wales and West Limited in 2013. In this case, the judge found that Parkwood's collateral warranty qualified as a contract, and so the Housing, Grants, Construction and Regeneration Act applied. However, recently, in July 2024, the Supreme Court reversed this position, overruling the Parkwood case and finding that collateral warranties are not contracts and will, in the large majority of cases, not be subject to the Construction Act. In the court's judgment, the key consideration was not the language of the collateral warranty, but its objective and purpose. As a consequence of this decision, employers and funders may press for the inclusion of an adjudication clause in future collateral warranties. And now moving on to completion or practical completion. It's important to understand the definition of completion in terms of a building project. What exactly does it mean? With general commercial contracts, completion is when all the obligations have been satisfied. However, applying commercial criteria to construction projects could expose the contractor to liability for damages. For JCT, completion is generally referred to as practical completion, which has been interpreted as allowing a state of less than full completion. Under the NEC 4, form of completion is defined as when all the work required by the works information is completed and that all notified defects that were prevented the client from using the project are corrected. This implies that completion can be achieved even if there are defects within the works, provided that the defects do not prevent the client from using the works. This said, there's no legal basis for determining practical completion, and if the works are not finished, then the client is not obliged to take possession. In the case of construction contracts, it is thought that imposing onerous criteria on construction projects could be seen as unfair, especially when minor but time-consuming tasks are outstanding. So, what happens at practical completion? Well, the contract administrator issues a certificate of practical completion, stating the date at which certain responsibilities are transferred to the client. For example, insurance of the works and security. In addition, half of the retention fund is released to the contractor, typically 1.5% of the certified sums, and the rectification period commences. During this period, defects and outstanding items are completed. Retention is a contentious issue with contractors and subcontractors and will be discussed in a future episode. The certificate of practical completion should include a list, often referred to as a snagging list, containing items still to be completed or that are outstanding. For smaller projects, a rectification period of, say, 3 to 6 months may be appropriate, while for larger projects, a period of 6 to 12 months is recommended. M&E installations could be longer. Two further scenarios in connection with completion are sectional and partial completion. It's not uncommon for there to be provision in the contract for sectional or partial completion, as in addition to the whole of the works being handed over to the client, at practical completion, the client may ask for partial or sectional completion when a self-contained portion of the work is handed over to the employer, whilst work continues on the remaining sections of the project. In such cases, there may be several periods of final measurement, releases of retention, etc., and they require careful monitoring, particularly where subcontractors are involved. So first, let's consider sectional completion. If a client wishes to take possession of sections of the work without the whole of the works being complete, then this will usually be anticipated and stated in the contract documents. This is in order that contractors can take this into account at the tender and program stages. For example, in the case of a mixed-use development, the retail units could be available prior to the other parts of the development. In the case of sectional completion, the release of retention monies should be calculated in proportion to the value of the section of the works completed, and in addition there is a requirement for the final accounts to be prepared and the start of the rectification period. Any details of phased handover will be entered into the conditions of contract. And now to partial completion. Again, sometimes a client may want to take possession of part of the works, but without previous arrangements in the contract documents. Under these circumstances, partial completion can be requested which, under a JCT contract, cannot take place without the consent of the contractor, who may not unreasonably withhold their consent. Again, partial completion usually anticipates discrete parts of the work being taken into the possession of the client at an early stage when the same process of calculating retention releases and the rectification period is applied. And finally in this podcast, the continued fallout from ISG. Details of the financial position of ISG are still emerging, but reports appear to show that the black hole may be nearer to £500 million, brought about by the contractor chasing work outside their expertise in an attempt to maintain cash flow, the euphemistically called legacy issues. Construction firms accounted for nearly 16% of all insolvencies in England and Wales in July 2024. That's according to the Insolvency Service, with 339 registered construction businesses going to the wall. Incidentally, the amount owed to start insolvency proceedings is comparatively low, at £5,000. In the year to July 2024, the total number of construction firms becoming insolvent was just over 4,300. Given the cyclical nature of construction, if asked directly about potential financial difficulties, many companies are likely to deny that there are any issues, in the hope of navigating through what they consider to be temporary financial ups and downs. However, despite these reassurances, there are several warning signs that may indicate financial problems, including a lack of or reduced staff on site, and slow or no progress of the works. In addition, equipment or materials may be removed from the site. Contractors may have difficulty in getting materials if credit is being denied or withdrawn by builders' merchants, and request changes to the payment terms. Interim payments may start to include inflated applications, as well as unjustified claims for variations, loss in expense, or contra charges. In addition, there may be rumours about a contractor's financial position, either in the press or word of mouth, because, you know what they say, there's no smoke without fire. In addition, official announcements to shareholders, the stock market, such as profit warnings or redundancies, may be made. There is also publicly available information which gives an insight into the financial position of a company, such as recent company accounts, court judgments, etc. In the event of insolvency being imminent or having occurred, there are several steps that can be taken to minimise the disruption to the project. These include taking possession and securing the site and or securing goods and materials that have been paid for by the client. A full survey and valuation of the contractor/subcontractor's works at the time of the insolvency should be undertaken to assist with the preparation of any post-termination insolvency account. Examine the contract to determine whether replacement, all risks or other insurance needs to be obtained, and whether any bonds or guarantees can be called on. And while still on the contract, have warranties been obtained from the subcontractors, and do those warranties contain step-in rights, which permits the beneficiary to take the place of the original contracting party and operate the contract in its place. If the supplier, contractor, subcontractor has entered administration, well, try liaising with the administrator to see whether the company might be able to continue with their works, or if an alternative company is being set up, which again might be able to complete the work. And finally, consider whether there are any key staff within the insolvent company that might be helpful and taken on to assist with project completion. It was announced by the administrators for ISG at the end of September, in a document released by them, that any amounts owing to subcontractors will be classed as an unsecured claim. And unfortunately, it is not anticipated that there will be any funds available for a distribution to unsecured creditors. The administrators also offered some fairly useless advice for subcontractors who are owed money. I have to say that the health of UK construction gives me great concern for a number of reasons. McKinsey & Company recently reported that, despite individual companies' efforts, construction productivity lags behind productivity improvement for the total economy, and that few construction companies actually measure productivity. Technology uptake has been slow and is mainly focused on control rather than productivity, and has been widely reported in the United Kingdom the sector is expected to lose about a quarter of its workforce within the next 15 years because of retirement. Projects have become more complex, exposing construction companies to more risk. But despite high risk, construction is a low-margin industry, leading to low amounts of investment. Despite talk of value for money, come on, everybody knows the lowest bid often wins. However, winning bids often come from the contractor with the largest underestimation of risks, rather than the one who is best placed, most predictive, and can deliver value for money. In a recent edition of Building Magazine, Mark Farmer suggested that combined legislative interventions on prompt payment, project bank accounts, procurement, and self-employment against PAYE incentives are needed to fix the construction industry. Will this ever happen? Answers on a small postcard, please, to... Well, that's all for this episode. I hope that you found it interesting. This has been a podcast from Duncan Cartlidge Online. Thank you for listening. Please, I would really appreciate it if you subscribed. And from Barney and me, until next time, take care.